When will we know if the minimum exempt salary level in the US will actually increase on January 1st? What are you doing on Friday, November 8th? I'll tell you what I mean, but backing up. In April of this year, the U.S. Department of Labor issued a rule to increase the minimum exempt salary, meaning the minimum that you have to pay most employees to classify them as exempt. That no matter how many hours they work, you don't have to pay them overtime. You can pay them a flat salary. And it scheduled that to happen in two jumps. The first was a jump on July 1st of this year, to go up from the previous level of almost $36,000 to almost $44,000. And another jump that's scheduled for January 1st, 2025, to go up to almost $59,000. Now, there's some carve-outs for this. So, for example, a group of professionals, which includes lawyers, doctors, and yes, teachers, those are exempt. They don't have a minimum salary, and yes, teachers are lumped in with them. Also, outside sales professions, those who get a commission, certain ones, there's no salary level for them. There's also the highly compensated employee exemption, which means a higher level, which is over $100,000 and is going up as well. And when you're paid that much, then the Department of Labor looks less at what you actually do. But anyway, for most employees who are classified as exempt, that minimum salary jumped from, again, to almost $44,000 July 1st and is going to go up again to almost $59,000 in January 1st, except for a very specific employer. And what do I mean by that? Well, after the Department of Labor issued this rule in April, different groups went to court. And I'll skip ahead because I've done videos on this, but there are 3 active lawsuits still challenging them. And they're challenging, yes, they're still challenging this July 1st jump that already happened, that most employers had to comply with. They're challenging the January 1st jump that's scheduled to happen. And also after that, as part of this rule, is that instead of what happens now, that the Department of Labor has to actually issue this jump, and then it gets challenged in court, they have an automatic one. So every 3 years, which, yes, is the term for that is triennial, that every 3 years there'll be an automatic increase. Those are the 3 parts of it, the July 1st, the January 1st, then this every 3 years increase. So in these lawsuits, the one main one was filed by the state of Texas. And there are a bunch of other parties that have been consolidated into it, like the Plano Chamber of Commerce, and virtually almost every national blank association, trade interest group, are all suing about this increase, saying that the Department of Labor does not have the legal authority to make this big of a jump. And they're looking at prior court cases on that. So some people are like, wait, what about Chevron deference? And that's gone. Well, under that, a case called Loper Bright under the U.S. Supreme Court didn't say that government agencies like the Department of Labor can't make any rules. It's just that they have less deference when courts are going to look at them. So courts can look at them with fresh eyes. So in short, it is easier now, under that legal authority, for courts to strike down government agency rules like this one. But so what's happened is the state of Texas, in its case, had asked for this July 1st to get increased, this increase to get halted, and the judge there did halt it for the state of Texas as an employer. So not like any employer that happens to be in Texas, but the state of Texas as a government employer. So what you've had is every employer that it applies to, and the FLSA is pretty broad. It's not one of those that looks at employee count. It looks at revenues, but again, most businesses this applies to, and so this $44,000 almost current level applies. And it is, again, scheduled to go up to almost $59,000. But what happens is when the judge had said, okay, this is halted for the state of Texas, the judge had said, but I'm going to look at this overall. And part of the reason the judge had said, this Judge Sean Jordan, a federal judge in Texas in district court, had said, well, Texas, you showed how this would impact you, but we're not going to halt this for all employers nationwide because you didn't really show how this would impact anybody else. And so that was the standard. And so a lot of, I think, other employers were like, yeah. So what you have is right now, this case by the state of Texas that has all these other employers, this judge, Sean Jordan, is now looking at this instead of just the temporary halt. They're looking what's called on the merits. So he's going to decide whether to halt this overall and whether this is illegal. There's 2 other cases. One is also in Texas, a case called Flint Avenue. And this one's a little funkier. It's a smaller business, and I won't get into the nitty-gritty of that. But that one now is fully briefed, meaning both sides of the case have issued the paperwork, so it's in the judge's hands to decide, look, what's going to happen. Are we going to halt the rule, or is the judge in the state of Texas going to halt the rule? And there's one other case, which is the Association of Christian Schools. That case had been filed in Tennessee, got moved to D.C., so it's in the D.C. Federal Circuit. That case also now is fully briefed. So you have these 3 cases, 2 in Texas Federal Court, 1 in D.C. Federal Court, of what's going to happen. Now, yes, all of these different judges could have different rulings. And I'm very curious about whether the judges, because the judge in the state of Texas suit, Sean Jordan, had already issued this decision and is had fully briefed everything is waiting to issue this big opinion on whether to halt this nationwide, whether a judge in the Flint Avenue case and then the DC Association of Christian Schools case, whether those judges wait for the state of Texas judge to issue their decision. If you're a federal judge, happy to hear you in the comments. But the question is, okay, so all three of these cases, because state of Texas has been fully briefed, that one was first done. And so I've been tracking these dockets regularly on PACER, which is this federal court system, to see if a decision comes out, because that's kind of how it happens. You just get a notification. But yesterday on Halloween, Judge Sean Jordan scheduled a hearing on November 8th, I think at 11 a.m., in the state of Texas case to hear the sides on whether there should be a halt on this rule nationwide and whether for any employer it wouldn't take effect January 1st. And so a lot of employees will be looking at this because when it happens, employers have to make a decision. Okay, do we increase our employees to bring them up to this federal minimum, this 44,000 almost 59,000? Do we convert those employees who would be under that 59,000 minimum? Do we convert them to non-exempt? Meaning all of a sudden you figure out the hourly rate. Now they have to track their time, potentially get overtime, do all of those things. And so a lot of employers are looking at this and a lot of employees likewise for their budgets. So Friday, November 8th is the hearing. And if you're wondering, okay, what happens? Is a decision happening at a hearing? That can absolutely happen. But you can also look at what's happened previously in that same case, which is Judge Sean Jordan on June 24th had a hearing about that initial preliminary injunction in the state of Texas. And he did issue a written opinion 4 days later on June 28th. That's when he halted the increase from taking effect for the state of Texas. So while it's possible, and I don't think I can watch it anywhere online, sadly, but we'll be watching what happens in that hearing next Friday morning, Central Time, it's possible he may take a few days to issue that written opinion. So we will see. And so the other cases as well, I mentioned the Flint Avenue case, I'll put the sites for that, Association of Christian Schools. Again, it's possible those judges could issue other opinions. So right now the opinions would either be yeah, this is fine and it'll take effect January 1st, or no, this is illegal. And you can look at some of the rationale from Judge Sean Jordan. In that case where he halted it for the state of Texas, his language very much painted the picture that I think a lot of people looking to this would expect him to halt this increase so it would not take effect January 1st because of the things he said, that likely they did not have authority for this. So again, we'll see. I will certainly be watching, but I know a lot of people, HR, finance departments, also employees are wondering, is this going to happen? Because then what happens is if Judge Sean Jordan or the judges in the other two cases, Flint Avenue or Association of Christian Schools, if they say, no, this is illegal, you can't have this increase, I mean, it's kind of a legal term for awkward, but you may have organizations, employers who did increase salaries to almost $44,000 July 1st. So people may say, what do you do? Again, if the rule doesn't take effect and is stricken, then that minimum salary level goes down to $36,000. Everybody has to make their choices, but I generally say in casual conversation, and if employer decreased its employee salary to go back down to it, then employees at that company would likely be making videos just like this, and you'd probably see them on TikTok. So don't know that that's the approach, but anyway, that's what's happening. So I'll be watching on Friday, November 8th to see what happens in that decision in the state of Texas. And like many things, we'll just have to see what happens.